Okay. Ms. Zapata, we'll need you on this case. Oh, I can't hear you.
Yes, I hear you.
Can you hear me now, Your Honor?
Yes.
Okay, great.
All right, we're on the record in 23 CCR 236271, State of Texas versus Ricardo Alberto Martinez Rodriguez.
Este es el caso 23 SR 236271, el caso de Ricardo Alberto Martínez Rodríguez.
If I could have the interpreter raise her right hand, let me go ahead and swear you in.
Yes, Your Honor.
Do you solemnly swear or affirm that you will truly and accurately translate from English to Spanish and from Spanish to English, so help you God?
Yes, Your Honor.
Very good. All right, we're here on a motion to set aside forfeiture. Mr. Lopez, you can get us started, but please pause to allow for interpretation.
Estamos
Yes,
aquí
sir. Thank you. Sorry. Go ahead.
un pedimento para dejar sin efecto el restablecimiento. Please continue.
Great. Thank you. Judge, so yes, I filed a motion to reinstate bond on this case. Mr. Martinez was set to appear, I believe it was in March, late March. And he failed to appear. I did appear for him. However, and I was able to get a hold of him that day. And there seemed to have been some miscommunication with our office in regards to him having to appear in person. By the time that he was able to get to court, I believe the bond forfeiture was already set.
Sí, bueno, su señoría, entonces cursamos el pedimento para dejar sin efecto o restablecer la fianza, disculpe. Y este pedimento fue cursado ya que el compadecente, el acusado, no se presentó a su audiencia, era marzo, casi a los finales de marzo, y entonces hubo una mal comunicación entre el compadecente y la oficina, pero él pudo llegar, pero ya estaba desestablecida la fianza.
So, Judge, at this time, we'd ask the court to reinstate his bond. It wasn't that Mr. Martinez wasn't trying to avoid appearing, is that he wasn't communicated effectively what his responsibility was by our office.
Entonces, su señoría, yo pido de que restablezcan la fianza del señor Martínez. No era de que él no estaba intentando presentarse, sino que había una dificultad de comunicación, un problema de comunicación entre él y el personal de mi oficina.
State, what is your position?
Judge, the defendant should have received a docket control order laying out all the dates and when he should appear on his first date. However, I recognize he is a Spanish speaker, and I do not know if he was provided a Spanish DCO. If it wasn't English, then I recognize he was probably reliant on his attorney for telling him when and where he needed to appear. With all that in mind, if it was a mistake, then I'm unopposed, but ultimately I'll defer to you, Judge.
Sí, bueno, su señoría, entonces la fiscalía entrega una orden cuando compadecen por primera vez, es una orden del control de todas las audiencias, entonces él tuvo que haber sido notificado, más sin embargo, no sé si a él le entregaron una copia en español. Dado a eso, su señoría tal vez se apoyó en lo que le decía su abogado, entonces sí reconozco ese error, pero se lo dejo a su decir.
All right, I'll reinstate his bond. I'll grant your motion. The
Thank you,
docket
Judge.
will go back in place.
Yes, sir.
Restableceré en la fianza y entonces su caso estará en la lista de mis casos.
He has a status hearing on May 23rd at 2:30 p.m. He will need to make up his discovery compliance hearing docket. Let me give you a date for that. Hold on.
Yes, sir.
Entonces él regresará para una audiencia evolutiva el 23 de mayo a las 2:30 de la tarde. Él va a necesitar una audiencia para la revelación de las pruebas. Déjeme darle una fecha. Permítame un momento.
May 22nd, 1:30 p.m.
22 de mayo a la 1:30 de la tarde.
And his presence is required, correct, Judge?
That is correct.
Su presencia es requerida, ¿verdad, su señoría? Sí, eso es correcto.
Okay, there shouldn't be any confusion going forward then, Your Honor.
All right,
Muy
very
bien,
good.
entonces ya no habrá otra confusión de aquí en adelante, su señoría. Muy bien.
All right, that concludes the hearing. You and your client are free to go.
Eso concluye nuestra audiencia. Usted y su cliente se pueden retirar.
Thank you, Judge.
Thank you.
Okay.
Ms. Zapata, we hang tight for 1 minute. I think we might need you on one other case.
Yes, Your Honor.
Can I have Oscar Pineda, an attorney in the attorney-client meeting room?
Make him here, see them.
All right, we're on the record in 22 CCR 228680, State of Texas versus Oscar Pineda Veleda. Mr. Rivera, it's my understanding your client may need an interpreter.
I don't believe so, with all due respect.
I had a note that an interpreter may be required on this case. Okay, if that isn't the situation, Ms. Zapata, you're free to go. Thank you.
Thank you, Your Honor.
Your Honor,
Yes.
this is a status setting. I have no announcements other than stick with the scheduling order. I've been discussing the case with my client. We're fine with the scheduling order.
Okay, and your next date is going to be on 8/15 for your pretrial conference. We'll see you then.
Thank you, sir.
Thank you. Free to go.
Your Honor, if I may really quickly, Mr. Rivera, your client needs to go get a CJIS done at the sheriff's office still.
I can take him right now. I'm heading over there on another case. Thank you. We'll do that right now.
Okay, thank you.
Thank you, Judge.
Thank you. You're free to go. Mr. Newsom, would you please start your video? Mr. Newsom.
I'm
Mr.
having my
Gaffney?
office reach out to him, Your Honor.
Okay. Tell you what, I'm gonna go to the next case. I'll come right back to you.
Understood.
Just mute yourself for now. I'll leave you in here.
Thank you, Judge.
Sorry about that, Your Honor.
We'll handle your case real quick. 1 second. All right, we're on the record in 22 CCR 230725, State of Texas versus Tremaine Newsome. We're here on a motion to release property, specifically a firearm. Ms. Saylor?
Yes, Your Honor, we're here. It's our motion that we filed. Mr. Newsome was originally charged with DWI second and unlawful carrying of a firearm. After negotiating that case, the DWI offense was reduced to a reckless driving offense, and the accompanying unlawful carrying of a weapon was dismissed. There was no forfeiture of the weapon, no agreement or order submitted at the time of his plea. And so our office filed within 61 days after the plea agreement was effectuated, filed the motion to release. It was my understanding, pursuant to some communications we had with the court, that the state was unopposed or deferring to the court.
State?
Judge, I'm unopposed to the defense's motion.
Okay, motion's granted then.
Thank you, Your Honor.
You're very welcome. Y'all are free to go. I'll sign the order shortly.
Thank you, Judge. We appreciate it.
Thank you, Your Honor.
You're welcome.
Good afternoon, sir.
Good afternoon.
Where's somebody else at? Oh, there they are.
Mr. Smith, would you start your video? Mr. Smith, would you start your video, please? All right. We're on the record in 23 CCR 233-911, 233-990, and 233-989, State of Texas versus Joshua Ryan Smith. Mr. Yeverino, would you care to give the court an update on this case?
Sir, working through a compromise. Mr. Gavin and I had a conversation previously and today as well about this case. I think we're almost to an agreement. I just need to verify some things with my client and finalize the final terms.
Okay. Next setting will be on 8/15. That's your conference at 9 a.m.
Yes, sir. Hopefully we'll get it done before that.
Well, let's wrap it up by then, or it's going to go to trial.
Yes, sir. No problem.
Right. Very good. Thank you, Mr. Yeverino.
All right.
You and your client are free to go.
Thanks, sir. Appreciate it.
Good afternoon, Your Honor.
Good afternoon, Ms. Parker.
Good afternoon.
We're on the record in 23 CCR 233894, State of Texas versus Michael Berkmeyer. Ms. Parker, would you care to give the court an update?
Yes, Your Honor. I've spoken with the state regarding the evidence in this case. We were waiting on toxicology results. The state has informed me that the results are not ready and apparently were not actually sent to the lab for testing yet. They are working on getting that submitted in order to get the results from that. Mr. Berkmeyer is currently at Coastal Bend ISF, and I think they're expecting to do an exit plan with him around the 19th of this month.
Okay. State.
Your Honor, a little bit of clarification on that. I had an investigator look into the results of the toxicology. Their contacts at the sheriff's office indicate that the lab test may never have actually have been sent to DPS. I have sent requests to DPS Crime Lab in Austin to see if they received any blood results from the sheriff's office, contrary to their records. I received a reply that they had a sample and that it was queued to be tested. However, I'm not sure if that's an automated message or not. So I need to look into that further. And that's what I've communicated to the defense.
Okay. All right. Your next setting on this case is going to be pretrial conference on 8/15 at 9 a.m.
Yes, sir. Thank you, Judge.
Thank you. Y'all are free to go.
Thank you.
Mr. Taylor, if you'd start your video, please. All right, we're on the record in 23 CCR 234252, State of Texas versus Robert Telford Taylor. Mr. Doggett, would you care to give the court an update on this case?
Judge, I've been emailing back and forth with Ms. Chapa, and we're trying to find a time that we can actually talk on the phone. I'm going to try to schedule a time to talk to her sometime tomorrow. I've sent her a letter from my client's psychiatrist as mitigating information, and we just need to have a discussion about the case at this point.
Okay. Next setting is August 15th at 9 a.m. for a pretrial conference.
Your Honor, I did want to bring to the court's attention, I spoke with the complainant yesterday, and she informed me that the defendant had sent a letter addressed to her through a third party, which is in violation of his bond conditions on the no contact condition. This wasn't reported to pretrial because he is not at this point required to check in with one, but I just wanted to bring that to the court's attention. I sent the letter to defense counsel. I just received it today and I sent it to him today.
Yeah, Judge, the letter was sent to her divorce attorney because they're in divorce proceedings as far as I believe it's still going on. So Alex Bement is the complainant's divorce attorney. So he sent a letter to the divorce attorney. And I will remind him that under the bond conditions, he's not supposed to have any contact with her. I know he had a protective order, but that has since expired. That was through the 387th. So I'll remind him under the bond conditions that he can't have any contact with her.
If you want to proceed on a bond violation, Ms. Chapa, file your motion. We'll set it for hearing and have a hearing on it. Right now, I'm not going to take any action on it, other than the fact that I'm going to take Mr. Doggett at his word that he's going to inform his client that his bond condition states that the suspect shall have no contact or attempted contact, whether in person, by electronic communications, in writing, through a third party, or otherwise, with the complainant, Vicky Taylor, or the complainant's family members. Now, sending it to the divorce attorney of Miss Taylor doesn't seem to violate that condition, but sending it directly to her by any means, or you know what, just addressing the letter directly to her could potentially be a violation.
Yes, Judge.
All right. Thank you, Mr. Doggett. You're free to go.
Thank you.
All right, we're on the record in 22 CCR 230209, stated Texas versus Jose Alberto Portillo. Mr. Peebles, would you care to give the court an update, a status update on the case?
Yes, Your Honor. Since the last setting, Ms. Chapa has shared with me 24 videos that we've reviewed. I've gone over with my client. She and I have been involved in active negotiations in an attempt to work this out. I think that discovery has completed now. I don't know of anything that's still outstanding. So we are going to put together a mitigation packet and attempt to secure a pretrial intervention as a way to resolve this. And if we can't reach that resolution, then we'll be prepared for the pretrials conference, which I think is already scheduled for sometime like August the 1st, I believe.
August 1st, 9 a.m.
Yes, sir.
Okay. Thank you for the update. You and your client are free to go.
All right. Thank you, Judge.
Your Honor.
Yes, Mr. Venza, you there?
Yes, Your Honor. I'm sorry about that, and I apologize for my attire today. I really do. I didn't realize that this matter was set for a hearing until my client texted me at 2:30, so I do apologize. The status of this case is that we're waiting on an offer from the state, and there's a pending felony in this matter.
Hold on. Let's get your client fully connected. So he's.
Yes, Your Honor.
All right. Okay, I think he is fully connected now. We're on the record in 23 CCR 233126, stated Texas versus Christopher Moore. Mr. Venza, thank you for the apology regarding your attire. I will allow you to proceed. Why don't you go ahead and proceed with your update?
Thank you, Your Honor. So we are awaiting a plea bargain offer from the state on this case. The defendant has a pending felony, and the state had been withholding a plea bargain offer, I think, in hopes that the felony was going to be resolved, which it's not yet at this time.
Well, we still have a little more time to figure out if the felony will resolve this misdemeanor. His pretrial date, which is the next setting, is on August 1st. So he's got a little time. Yes.
May I make a request to the court? As reflected by Mr. Venza, there is a pending felony that did arise out of this transaction. I was requested by the felony prosecutor not to resolve this case until he's had the chance to potentially resolve the felony. Further, Your Honor, this defendant does have at least 2 other offenses within this court from a separate transaction. My request to the court is ultimately to, I guess, align this case with the earlier docket control orders of the other cases to potentially allow us a little bit more time for resolution on the felony, and it would allow us to keep all the cases together within this court and potentially resolve them all together. I know it's not within the general procedure of the court to alter the docket control orders or allow more time beyond what they are, but I would represent to the court that in this context is a little bit different and there are other factors at play. So I would make that request to the court, Judge.
Mr. Venza?
No objection.
Okay, can you have your client here this Friday morning, tomorrow morning?
I believe so, Judge. Yes.
Okay.
If I could have a moment, yeah, I'm sure that'll be fine.
So what I'd like to do is have you and your client come in tomorrow morning, sign off on docket control orders that put all of his cases on the same dates. I will give the state a little more time for a trial date, but it's not going to be much.
Yes, Judge. Thank you.
Thank you, Your Honor.
Okay. All right. We'll see you tomorrow morning, you and your client both, Mr. Venza.
Okay. Thank you. Thank you, Judge.
Thank you.
May I be excused?
Yes, you may.
Appreciate it.
Hello, Judge.
Good afternoon. Mr. Segura, are you on both of Mr. Walker's cases?
No, Judge, but it's very likely that resolving the DWI will resolve both.
Okay.
And we're still putting together a mitigation packet. I've had an ongoing family emergency that's kept me out of the office for the better part of the last 2 months. So I'd like another week to get that done.
That's fine. Let's give your client a second to fully connect so he can hear everything. All right, Mr. Walker, if you would turn your video on, please. Mr. Walker, if you would turn your video on, please. Mr. Walker, are you there?
I'm trying to unmute it. There you go.
There we go. All right. We're on the record in 23 CCR 232196, State of Texas versus Willie Walker. Okay, Mr. Segura, you were saying that you're putting together a PTI packet on this case?
Yes, Judge, on the DWI.
Okay. And you just needed some more time. That's not going to be a problem. Your pretrial conference is not until August 1st. So you've got some time to get a pretrial resolved with the state.
Very good.
Okay, anything else you'd like to inform the court of?
No, sir.
All right, you and your client are free to go.
Great, thank you.
Yes, Mr. Walker.
No, that's fine. Thank you, sir.
Thank you. Y'all are free to go.
Thank you, Judge.
Good afternoon, sir.
Good afternoon, Mr. Brown. I show that you are set for a plea on this case on April 26th. Is that correct?
Yes, sir. If I'm able to, I just got off work. If I can come in today to sign the paperwork for Ms. Chapa, I can sign the paperwork for her right now. So that way on the 26th, we can be kind of in and out. If that helps. If it doesn't help, if it's not going to make a difference, I'll just be there on the 26th.
You could go and get the paperwork from her to sign off on. Is that a problem, Ms. Chapa?
Not at all, Judge.
Okay. Why don't
Okay.
you run down there and grab the paperwork, Mr. Brown?
Yes, sir. It takes me about 45 minutes to get there, but I'm on the way right now.
Not a problem. Thank you. You're free to go.
Thank you very much. Yes, sir. Thank you. Sorry, I'm not very good at Zoom.
All right, we're on the record in 23 CCR 234707, state of Texas versus Muiwa Fapunda. Mr. Ngolo, are you still announcing ready for trial on this case?
We're announcing ready, but we've come to an agreement.
I'm sorry, you need to speak up.
I'm having a hard time hearing you, Mr. Ngolo.
Yeah, we're announcing ready, but we've come to an agreement with the state.
Do you need to set this case for a plea?
It's essentially it's a bid class.
Okay, so he's got to take a class and then they'll dismiss at the end.
Yes.
Okay. How long is the class?
It's a 36-hour bid class, batterers intervention program class.
It's 2 hour each course, right?
Yes.
Each week.
This is an online one, so he may be able to. Oh, actually, it's an online one, so he may be able to finish before the 18 weeks.
Okay. Well, I'll tell you what. We have a pretrial set on August 15th. Let's see where he stands on that date, if he's completed it or not. And if I'll make a determination at the pretrial conference whether additional time is going to be allowed or not. Okay.
More than fair, Your Honor. Thank you.
All right. Very good. Thank you for the update. You and your client are free to go.
Okay.
How's that?
Mr. Torres, if you turn your video on, please. All right, we're on the record in 23 CCR 233946, state of Texas versus Sean Torres. Mr. Stevens, would you care to give the court an update?
Judge, we've reached an agreement. We will be pleading to a probation. So my next question is, would next Friday, the 26th, be an acceptable date to come in and do this, or do you have a different plan?
No, I think next Friday should be fine. Let me just double check. Yeah, next Friday, 9 a.m. That'll be fine. 426.
Well, the translator, Gavin, if you're hearing me, you can shake your head. If you can send me the paperwork ahead of time, I'll get it all signed up beforehand just to speed things up. That's all I had, Judge.
Perfect. Thank you.
Thank you.
You and your
Appreciate it.
client are free to go. I'll see you next Friday.
All right.